What I'm here mostly to talk to you about today is why the subcommittee has put these guidelines together and how we think that you and the lawyers who practice in your jurisdictions will be able to use them and how hopefully that will improve the practice in your local jurisdictions. And the main reason that we looked at these is under the Fair Defense Act, most counties have adopted experience-based qualifications as part of their indigent defense plans. And the Fair Defense Act assumes that counties will have standards that look at past experience and CLE as the basis for deciding who gets onto different wheels or different lists of attorneys who get appointments in your jurisdiction. But like Johnny D. was discussing this morning, experience is not enough. And I put Homer Simpson up here. He is not a lawyer, but he's been working at this nuclear plant for at least 20 years in our time. I don't know how long exactly that is in Simpson's time. So he is experienced in the sense that if you looked at his resume, he'd have lots of years under his belt and has done many things. But here he is sleeping. And this kind of rings up the sort of sleeping lawyer case that many of us have heard about for many years, and I think lots of people are tired of hearing about since it happened over 10 years ago. But one thing that's sleeping lawyer case shows us is it's a really interesting lens of the way to look at the fact that that lawyer had tried a lot of capital cases. So he would have met the qualifications that most counties have in their plan for handling capital cases. He would have had X number of trials, and he would have worked with mitigators, and he would have been able to show that he's been to 30 hours of CLE in the last year, but he still slept through a trial. So looking at past experience is not a sufficient lens to try to capture what makes a good lawyer and what we would want to see in lawyers who are approved to handle indigent cases or really any cases in your jurisdiction. And the Fair Defense Act has left space for these other considerations to come through. So if you look at the Fair Defense Act scheme, you guys have objective qualifications that were incorporated in your plan, and you can set them for different levels. You can require so many trials for misdemeanors and so many trials for 3Gs. But there's another element to how lawyers get on the list in your jurisdictions. As you know, the judges review those applications, and they have to vote to allow somebody on the list. So the Fair Defense Act, under the Fair Defense Act, meeting the objective qualifications in your jurisdiction is not enough to get on the list. If it was, the judges would not have to meet. They would not have to vote on these people. They would not have to make judgment calls about who gets on the list. An administrator could go just check the files and make sure that, yeah, they really did have 5 trials. So there already is an assumption in the way the Fair Defense Act is structured that y'all will be looking at something else, that judges will be looking at something else when they decide who gets on the list. And it's not really spelled out what that would be, and it's been, I know it's been a subject of tension in some jurisdictions. Some counties have been sued by lawyers who feel like because they met the objective qualifications that they had a right to be on that list, and they were going to sue when they didn't get on the list or when they got kicked off the list. It's also been a subject of tension where people thought that they were kicked off the list for political reasons, and some counties have had to look at putting together sort of due process procedures to make sure that lawyers were informed why and had a chance to respond to allegations. So this question mark has been floating around for a number of years and has caused problems in litigation and political fights in lots of jurisdictions, but it's not really spelled out what it should be. And what we hope at the State Bar and the committee that's been working on this is that you will look at these performance guidelines as something that helps fill in that question mark. Because the guidelines look at attorneys' current performance, what an attorney really is doing in a case on a day-to-day basis, and they don't look retrospectively at how many cases you've done, but they look at what are you doing and how does that measure up to what this group of lawyers who've been working on these guidelines specify should be baseline guidance for your behavior. So the guidelines talk about how quickly you should meet with clients, that you should consider bond revocations, that you should think about how to use an investigator in every case, and there might be some cases like a driving with license suspended where an investigator isn't appropriate, but there are lots of cases where investigation would be appropriate that looking at the investigation expenses that people report, it's very unlikely that people are using investigators in all the cases they should. So this is really formatted as a checklist or a list of considerations that lawyers can look at and that judges can look at when evaluating what attorneys who meet the experience qualifications, what they actually do, and how or whether they should be included on the list. And we hope that that gives people, that can resolve some of the tensions that have occurred at the local level, because it provides some objective guidelines that attorneys can be measured against that aren't experience-based, but that look at present performance, but they're objective. The attorneys can be given notice of what's expected of them in advance. And hopefully that will resolve some of these questions that have been raised on the back end when people have been kicked off the list and they don't know why. They've had 20 trials. What else were they supposed to do? So by providing some transparency and some objective baselines, that can hopefully help simplify this process and clarify it and get everybody, the lawyers and the judges who screen them, focused on how people are currently handling their cases, what they're doing every day in court, and not just looking at what they've done in the past. And the last reason that the committee has really looked at this is we felt that other avenues to address problems with attorney performance were not adequate. Not only were the experience-based qualifications alone not sufficient to get the right attorneys on the list, when people tried to deal with bad lawyering through other ways, that they were sort of hitting dead ends, spending money and not getting results that helped clients. So on appeal, as most of you know, if you have a case go up on ineffective assistance of counsel, the courts will look at a floor. So they're going to look at, did this affect the trial outcome? That's not going to help address problems with lawyers who are not meeting with their clients promptly, because if the timing of that meeting did not affect the outcome of the case, the guy probably would have been convicted. The courts aren't going to mess with that, even though that means that defendants are sitting in jail maybe when they don't need to be, when they could get a modified bond, and they're in your jail costing money when they don't necessarily need to be. So there are lots of things about attorney performance that are not going to get caught on appeal, because the court does not look globally at attorney performance when it's looking at ineffective assistance of counsel claims. And then the disciplinary review process was not working effectively to screen bad attorneys either. Before the committee adopted these guidelines, they actually filed a couple of grievances against death penalty attorneys who did not meet their clients before filing a post-conviction writ. And even gross failures like that were rejected by the disciplinary committee, which took the position that policing bad lawyering is not a disciplinary issue, it's a courts issue. The courts look at bad lawyering on IAC, and that most things that are bad lawyering are not disciplinary violations, and that they weren't going to get involved. So on the back end, the bar disciplinary process wasn't working, and so the Legal Services to the Poor and Criminal Matters Committee wanted to engage the bar in playing an effective role in policing its own, and do it on the front end when it can really help clients. Go ahead. So I'm going to wrap up this part just by talking about how these can be used by attorneys and by your jurisdictions. For attorneys, lots of new lawyers graduate from law school in Texas, and because we don't have public defender offices, they might just go start practicing criminal defense lawyers as criminal defense lawyers on their own, hang out a shingle. That's fine, but they're not getting training as they get started in the field. And these guidelines can be a way for people who are new lawyers to get training in what's involved in day-to-day criminal defense practice, what they should be thinking about as they handle these cases, because that's not something that's frequently covered in law school. And there are not lots of places like public defender offices to get that training in a systemized way in Texas. It's a checklist for lawyers of any experience level. You know, once you've handled 100 cases, you know, it's pretty easy to get on autopilot sometimes, and this is a way to make sure, just for yourself, that you're thinking about everything that you might do in a case. Most of these things are just things that you should consider. And it makes sure that even experienced lawyers are considering in every case questions that may not have come up in their last 50 cases but may be relevant in the case they're handling right now. And finally, they can be used as an evaluation tool. Both lawyers who want to take a hard look about how they've been handling their cases. Have they gotten into a rut? Are they routinely skipping things that they should think about doing? And they can also be used within the PD offices that do exist in Texas as an evaluation tool. And probably more relevant to the audience here today, how can counties use the guidelines? You guys can include them in your indigent defense plan. We've seen this in many of the regional capital plans where the capital guidelines are either explicitly incorporated into the capital attorney qualifications, or the attorneys are required to read and affirm that they will abide to them in a way that was discussed, that the San Mateo office does with their guidelines. They can, as I've discussed, inform the judicial screening of people who meet your objective qualifications, your past qualifications on your list. These are considerations the judges can use when deciding, out of these people who have 10 trials, who really is performing well and who should get on the list. And finally, they provide greater consistency in the delivery of a government service. Indigent defense is something that counties are paying for, taxpayers are paying for, and right now they're getting results that are all over the map. They're getting performance that's all over the map. You get people who show up for 5 minutes and plead a case out. You get people, you have quality is all over the place, practices are all over the place. This is a way to ensure, if you get lawyers to buy into these guidelines, that you're getting a more consistent service in your jurisdiction across the range of defense lawyers who are handling cases for you. And then just the last thing is an update on the status of where these are, so you can kind of know when they're coming. That's the next slide. In March, we sent these out to stakeholders throughout the criminal justice system for feedback and for any suggested amendments. It was sent out to everybody who was listed as an indigent defense contact by the task force, because I could send that to you guys by me. And it was also sent out to judges, and we have a big mailing list of people who we've communicated with on indigent defense issues over the years. And it also went out to the Criminal Defense Lawyers Association and to the CCA and to other people who were involved in that. Oh, I'm sorry. Yeah, these are the non-capital guidelines. Sorry about that. And then the committee reviewed a number of amendments that were brought to it by stakeholders and approved a final version of the non-capital guidelines in September, and they will be presented to the State Bar Board of Governors for initial consideration in January 2011, and we hope to get action, if not at that meeting, at one of the meetings soon after that. So that is the end of topic 1. I'm actually giving you 2 different presentations back to back, so we'll move into the misdemeanor defense part of the program, and I'm now wearing my TFDP hat. Texas Fair Defense Project has been working with jurisdictions and with individual defendants for a number of years about misdemeanor representation, and specifically the large number of misdemeanor defendants who proceed without counsel and who meet obstacles to receiving counsel in misdemeanor cases. We get lots of calls from people who say they can't get a lawyer, they don't know how to get a lawyer, they were told they couldn't get to apply to a lawyer, and that mostly happens in misdemeanor cases. The felony courts we don't hear this as much in the felony courts, but we did hear it consistently in misdemeanor cases. So we went out to look at this more systematically, and we've been working on a study for a number of years where we were able to go back in and take snapshots over time. And the study has 2 aspects. The first is a quantitative analysis, and we just have looked at how appointment rates have changed over time, basically since the task force started collecting data to the present. And then there's a qualitative component where we went to one county in each of the state's 9 administrative judicial districts and did at least 3 visits to observe their misdemeanor court practices and interview stakeholders. And we looked at that over different periods of time as the before and after the law around waiver of counsel changed in the 2007 legislative session. And I have a couple of slides just about the data that we found, and these slides are in your book. Basically, Texas's felony appointment rate has been in the low 60s pretty consistently over time. Misdemeanor appointment rates have been much lower. And this is looking at each county's appointment rate. So it's not taking the statewide total number of appointments divided by the statewide number of cases, which is a figure that I think you see frequently in the task force's report. But this looks at the county level. Where is each county's appointment rate? And it has been quite low over time, though there has been a spike in the last 2 years, or at least it's not a spike, but a slight angling upward. And we don't really have a causation explanation for that, but the two things that might have affected that is the Rothgary decision has changed some counties' practices in terms of how they handle requests from bond defendants, and then HB 1178 from the 2007 session clarified procedures for dealing with pro se defendants and talking to them about waivers of their right to counsel. Can you go to the next slide? And this is just a distribution. So in 2007, and frankly, trust me, every year prior to 2007, 75% of Texas counties were at 20%, had an appointment rate of 20% or lower. And in the last 2 years, that started to go down. Now I think we're about 65% of Texas counties are in this below 20% box. We have 7% of counties still at 0%. And then you can see the bars get much shorter as we move to appointment rates in the 35%, 50% range. And there are also trends to how this breaks down based on county characteristics. So for example, larger counties on average have higher appointment rates than smaller counties. And again, you can track this. This is in your book. I'm going to move pretty fast just for time reasons. The kind of appointment system that a county has, there's at least a correlation to its appointment rate. So, appointed counsel systems, have pretty high bars in the 0 to 10%, 10 to 20% range. So do contract defender systems. Public defenders are represented, have higher representation in the 20% brackets and above. So public defender offices have higher appointment rates. Again, there's no data to prove the reason for that. But I think in a lot of counties, once you have a public defender and once judges aren't thinking this case equals $200 or whatever your flat fee is, it overcomes some sort of mental reluctance that judges might have in a per fee system to assigning counsel in marginal cases. Go to the next slide, please. And then finally, county court at law counties have a higher appointment rate than counties where misdemeanor courts are handled by the constitutional county judge. So again, those are smaller jurisdictions where you have a constitutional county judge. We haven't quite sorted out what that might be other than it could just be the size difference. But also county court at law judges often are not judges. They're not required to be judges. And so, constitutional county court judges. So some of them who represent misdemeanor cases may not have a legal background in terms of handling requests for counsel or informing defendants about their rights. We saw lots of practices when we went out to counties around the state that, to me at least, start to explain why you see so few appointments in misdemeanor cases. And this is just a picture of a notice we saw outside a courtroom when we were traveling around. And, for example, in this case, if you show up, the sign on the courtroom door says, it's time for you to go talk to the prosecutor about your case. If you show up and you don't have a scheduled plea hearing already, please go talk to the prosecutor. And please tell the prosecutor if you want to dispose of your case by a plea bargain. And defendants saw this sign before they ever walked in the court, before anybody in the court ever told them about their right to counsel, before anybody in the court ever gave them a right to an opportunity to apply for appointed counsel. So this is an example of the kind of thing that we came across where defendants were allegedly waiving their right to counsel, but under circumstances where that waiver is not legally valid. Certainly defendants do not waive their right to counsel if they are not told that they have a right to counsel before they are sent to go talk to the prosecutor. So I will just wrap this up I am almost out of time. I made a little short video that instead of telling you about some of the practices that we saw, I made a video because these have been floating around with lawyers and why to go to law school or why not to go to law school. This is a little video about things that we saw that if you were doing some of these things in your county, please come talk to me.
You are here for the first appearance docket. This is your opportunity to talk to the prosecutor and see if you can work out your case.
I'm sorry, what? I've never been to court before. I'm supposed to talk to who?
You have the opportunity to talk to the prosecutor. This is not a very serious case. You may be able to work things out today. Then you won't have to come back again.
Well, that would be good. I may lose my job if I have to take off work again. I can talk to the prosecutor now.
Yes, right now. She's right over there. Then you can come back and talk to me. If you cannot work something out with the prosecutor, we can talk about the next steps in your case and what you're going to do about getting a lawyer.
Wait, the prosecutor isn't my lawyer?
No, she represents the state. She filed the charges against you.
Oh.
If you don't resolve your case today, you have the right to go to trial. You have a right to defense lawyer at trial. If you go to trial, you also have the right to a jury and to present witnesses on your own behalf and cross-examine the witnesses against you.
What if my case doesn't go to trial?
You also have a right to counsel if you plead guilty.
Okay, but I'm not sure if I want to go to trial or if it makes sense to plead guilty. Do I have a right to a defense lawyer now to help me make that decision?
Oh, well, yes.
I think I want to talk to a defense lawyer. My boss says that I may lose my job if I am convicted.
Okay then. I'll reset your case so you can go hire a lawyer. You'll need to come back in a few weeks with a lawyer.
Hire a lawyer. But I can't afford a lawyer. Don't I have a right to an appointed lawyer? That's what they say on TV.
You posted bond, didn't you?
Yes, but it was all of the savings I had. And I'm not making enough now to hire a lawyer. My hours have been cut at work because business is really slow right now.
But you're working, so you should be able to hire a lawyer. And you should work more, if that's what you need to do. You need to go talk to some defense lawyers and see what they will charge you. Come back with their business cards in 2 weeks.
Isn't there just some form I can fill out to show you that I can't afford a lawyer? When I was arrested, the judge in jail gave me a form like that, and I filled the form out and asked for a lawyer. What happened to that?
He probably didn't give it to me because you made bond.
Well, can I fill the form out again now? I have my pay stub with me if you want to see what I make.
I won't appoint a defense lawyer for you until you go try to hire some lawyers. And if I end up appointing a lawyer for you, you will need to pay the county back for the cost of that lawyer.
I still won't have money to pay for a lawyer at the end of the case. Maybe I will just go talk to the prosecutor and see what she has to say.
Okay. Next case.